Thank you. Please be seated. Good morning. We're here for oral argument in case number CV23-0818, Voliner et al. Versus Olson. The council, please just remind you we're recording and live streaming the argument, so please identify yourselves and who you represent at the beginning of your argument. Each side will have 20 minutes, but you're not obligated to use all that time. Appellant's counsel, you should watch the clock and reserve as much time as you wish for rebuttal. Also, keep in mind we've read the briefs, studied the record, and have discussed the case in conference. And counsel for appellant, you may proceed.
May it please the court. Good morning, Your Honors. My name is Robin Dugas. I'm with Community Legal Services, and I'm appearing on behalf of the appellant, Justin Voliner. Your Honors, we're here today to appeal an improper eviction. We are asking your help in determining whether the process of forfeiture under ARS 33741 et sec was applicable to the contract between the parties, and if so, were the required notices of forfeiture and the affidavit of completion of forfeiture timely recorded and delivered to the defendant, Justin Olson. In this case, there is a controlling contract fully executed by the parties. It is the only written agreement. It's not disputed that the parties intended for it to be a purchase contract with seller carryback financing. The forfeiture statutes are defined to include certain kinds of contracts, generally contracts where at the time of the final payment, the seller lender provides a deed to the buyer-borrower, transferring title, essentially at the end of the deal. That's not the case here. Real estate purchase contracts are excluded from the forfeiture statutes expressly. In this case, Mr. Voliner gave $75,000 as a down payment, and the parties intended to employ seller financing agreement. Those documents were not executed at the time.
So counsel, understand your argument. How do we make sure we don't violate the principle that's stated many times throughout in all of the case law governing forcible retainers, is that we may not inquire into matters of title? How does what you're saying right now not violate that principle?
So we're not arguing title here. We have a separate civil action in the Superior Court for issues of quiet title, specific performance damages. What we're saying here is that the method, the statutes that appellee Voliner employed to forfeit allegedly the agreement and then bring the eviction action don't apply here. They don't apply to this kind of contract, so they can't be used under these specific fact patterns. So it's not a question of title, it's a question of the statutes, the process that was used. Forfeiture is just not an available remedy under this contract and the facts. It's a pretty discrete issue. In addition to our position that the forfeiture statutes don't apply to this kind of contract, if the court were to find that they do apply, appellant argued that they weren't applied appropriately. Multiple notices were delivered to Mr. Olson from Mr. Voliner, notices of election to forfeit. The third notice is the final notice, and that notice provided a 60-day cure period. So the notice was dated September 7th, and it gave Mr. Olson 60 days to cure the back amount before the alleged forfeiture would be completed. But that didn't happen. The affidavit of completion of forfeiture was filed within, I think, 3 weeks, and then the eviction complaint was filed on October 23rd. The 60-day deadline would have been November 6th of 2023. So he was denied his opportunity, the full 60 days to cure the affidavit of completion of forfeiture and the eviction, therefore, were untimely and should have been dismissed.
Let's circle back to the terms of the contract a little bit, and I want you to stay within the confines of the record, and if it doesn't say, it doesn't say, then, but help me understand, who was responsible for, or let me put it this way, who dropped the ball as far as the note and the deed of trust being signed and or title being transferred? None of those three things seem to have happened. Whose fault was that?
The contract itself is silent as to who's going to be preparing those documents. Obviously, the seller, appellee Voliner, would have been required to sign the deed, and then Mr. Olson would have had to sign the promissory note and deed of trust. These are issues that will be raised in the Superior Court civil action, because we would need an expert to testify as to the standard in the industry, who provides the loan documents, the lender or the borrower, and who's responsible for the transfer of title deed, the seller or the buyer.
So there was no close of escrow, even though the contract specifically said there would, or contemplate there would be a close of escrow.
No, it's kitchen table. Mr. Olson's brother had already given Mr. Voliner the $75,000 down payment, and then they brought the contract that Mr. Olson signed. It was just kitchen table closing.
Go ahead.
Okay. We don't want to stray too far from what we're here to appeal today. The contract itself is a real estate purchase contract. The statutes expressly exclude real estate purchase contracts. In the definition section 33-741-2, this type of agreement is expressly excluded from forfeiture. So it is our position that Mr. Voliner didn't have standing to bring this eviction action under these under this set of statutes, that the remedy here just doesn't apply, and that therefore the court should have dismissed the case.
Okay, let me ask you one question about fees. Did the court award, I believe the court awarded attorney's fees, correct?
Mm-hmm. Yeah, that's correct.
What was the authority for that?
It was asked for in the complaint, and it's an issue of contract.
12-3-4-101?
Yeah.
Okay.
Yes.
Thank you.
And is that the same basis that you're relying on for your fee request?
Yes, Your Honor.
Any further questions? Okay. All right.
Okay.
Thank you.
I appreciate your time. Thank you, Your Honor.
Good morning.
Morning.
May it please the court. Your Honors, my name is Mark Tucker, and I represent
Okay, thank you.
the appellees Jake and Tori Voliner. In this particular case, the appellant has asked this court to take judicial notice of notices of election to forfeit. We don't have a problem with this court taking notice of these documents that were recorded. The problem here is that what the appellant is actually asking this court to do is to rule on the effectiveness of these documents, which the eviction court, I believe, justly refused to do. And at the time the eviction action was filed, Mr. Olson had not responded in any way to any of the notices that were served upon him. The appellees had recorded a notice of completion of forfeiture. That was followed by a 5-day notice. Mr. Olson didn't respond to those either. When the eviction action was served upon Mr. Olson, then and only then did Community Legal Services come forward, and at that time they filed a separate quiet title action, which is currently pending before Judge Driggs in Superior Court. In that action, they sought to get a temporary restraining order precluding the eviction action from going forward. The eviction action was continued so that Judge Driggs could rule on that temporary restraining order application. He denied that request. Immediately, we went across the hall and completed the eviction action in which Commissioner Brian Kaiser ruled in favor of my clients on the eviction action. What the appellant is actually seeking in this action is on the appeal of the forfeiture of the forcible detainer action. They're seeking to have you make a decision, which is actually, I believe, for Judge Driggs to make in the quiet title action, which is not going to proceed to trial until 2025. So what they have not asked you to do is to take judicial notice of the completion of forfeiture. They're just taking issue with the notices of intent to forfeit. Admittedly, there are some problems with those notices. There is some math errors. There are some typographical errors. But at the end of the day, this is what we have. We have 3 notices which clearly state Mr. Olson had paid less than 20% of the total purchase price of the property. Under the law, he had 30 days to bring himself current. He never did that. He hasn't made a payment on the property since May of 2023.
Counsel, can you speak to your colleague's argument that the statute does not contemplate a forcible detainer action with the purchase contract that we have here?
Can you restate your question one more time, please?
I think your colleague's arguing ARS 33-741-2 and ARS 12-1173-01 don't allow for forcible detainer actions. Can you speak to your position on that?
So what she's, I believe, trying to say is that the parties had a current contract which could not be resolved with a forcible detainer action. If parties are in a buyer-seller relationship which is being breached, I think that breach needs to be resolved or determined before a forcible detainer action can be brought. Our position is that by going through the forfeiture process, giving notice, opportunity to cure, and recording the notice of completion of forfeiture, that process had been concluded. That relationship had ended. That's the purpose of a notice of completion of forfeiture. And at that point, an eviction action could proceed. It would be akin to a trustee sale concluding.
It seems like you're saying that just by doing that transformed or morphed, that the purchase contract thereby morphed into a agreement for sale or contract for conveyance. How do you have any legal authority for that?
Can you ask your question one more time,
So
sir?
how did they purchase? You don't disagree that initially, I'm just not trying to trick you, but initially it was a purchase contract. Do you disagree with that?
It was a contract for sale of real property, yes, sir. That's what the parties contemplated was.
It was not a purchase contract under the definition of what defines a purchase contract. I mean, you would what is a purchase contract? Let me start there.
Sure, it's an agreement between the parties where one buys one thing from another party.
But it's a term of art apparently because it's an exception to the forfeiture statute. If it's a purchase contract, you cannot conduct a forfeiture. Would you agree with that? And that's what ARS 33-741-2 says.
I understand, but Your Honor, what the appellant asked for in her request was that you take notice of these documents that were recorded, and what she's now asking is that this panel weigh in on the effectiveness of these documents and substitute your authority, your decision for what Judge Driggs is going to be ruling in the Court of Appeals.
I'm not sure that's what her argument is, but she can clarify that. But I thought, okay, let me back up. You won't disagree that your client had the burden of proof in this forcible detainer action, right?
Yes, sir.
To prove that under the statutes at issue or at play, whatever those statutes are, you needed to satisfy those statutes.
That is correct, Your Honor.
And that would include showing that it was not a purchase contract.
I don't believe I agree with you, Your Honor, but they have filed a quiet title action to have Judge Driggs make that determination.
And so didn't Judge Kaiser, by reaching the decision and saying that there is a forcible detainer here and granting judgment for your client, didn't he necessarily make the determination
No,
How could he make that determination without applying the statute as written?
Your Honor, I believe what Commissioner Kaiser did was refuse to preempt what the appellant had asked Judge Driggs to do by filing a quiet title action. He did not want to get into the merits of quiet title, which is what they were trying to seek with Judge Driggs and a temporary restraining order. He simply was going from the completion of notice of forfeiture and the determination of who had the right to possession. They are independent legal tracks. And so he wasn't going to second guess what Judge Driggs has been asked by the appellants to do. They are independent.
I understand what you're saying. The point, and it's a point I brought up with opposing counsel, that I understand that you don't inquire into merits of title, but there's also a competing proposition that or not necessarily competing, it's an additional proposition that the forcible detainer courts have to wrestle with from time to time, is there are prerequisites to getting the right to do a forcible detainer. That's the Colonial case. It says if there's a genuine dispute as to whether all the prerequisites for obtaining forcible detainer relief have been satisfied, if there's a genuine dispute as to that, then it's not proper in a forcible detainer setting. You go to a quiet title. I mean, what am I missing that this isn't? I see the purchase contract as, I'm getting hung up on that. I'm getting hung up on that is a prerequisite that you needed to prove that it was not a purchase contract as a prerequisite for obtaining relief.
I believe, Your Honor, what happened in the forcible detainer action is that Commissioner Kaiser didn't go into whether or not there was a purchase contract. What he said was there was a notice of completion of forfeiture. That is our starting point. And I don't even believe that what the appellants asserted clearly in the forcible detainer action was the nature and grounds of the contracts. They simply wanted to fight a quiet title action in the forcible detainer setting. And again, Commissioner Kaiser did not opine on the record, all the reasons why he was refusing to go down the road of a quiet title action. What he did was start with the notice of completion of forfeiture, and he was letting Judge Driggs handle the rest of it, because in response to the forcible detainer action, they filed a quiet title action. They're the ones who raised that in that case. And so what we're trying to avoid here on an appeal is to have you make Judge Driggs' determination on appeal, which it's a preemptive request.
In order to proceed with the forcible detainer, didn't Commissioner Kaiser have to at least implicitly determine that this is not a purchase agreement?
He didn't say that on the record. I believe, again, that he was starting not with the notices of intent to forfeiture, which is what appellants are focusing on, but his starting point was the notice of completion of forfeiture, which was followed by the 5-day notice. Again, Mr. Olson didn't respond to any of those things until after he was served with a forcible detainer action, and only then, with the assistance of counsel, did he come up with these legal theories.
Well, shouldn't his starting point have been, is this or is this not a purchase agreement?
That is a really good question. He didn't do that necessarily, but they did file a quiet title action objecting to these notices that they've raised today. And again, that's a decision for Judge Driggs to make, and they're asking you to make that in advance on his behalf.
I mean, we're going to speculate a little bit. So assume if we were to affirm here, and this goes back to Judge Driggs determines this was a purchase contract from day one. You could not, it was unlawful to do the forfeiture is void, null and void. I mean, assume that he could say that or declare that. I don't know that he would. I don't know how it would come out, but just assume that it's null and void. Then what happens with the forcible detainer? Does your client reimburse the attorney's fees and the time, I don't know if he's going to be out of the house, or, I mean, I assume that there's a stay, I believe, right?
There is,
Okay.
and Mr. Olson is still in possession of the property. Currently, he's paying the supersedious bond to stay the enforcement of the writ of restitution. Your Honor, you're asking me how will the courts in the future rule? I don't know. I'm sure the parties can reach some kind of position so that the status quo can be maintained, but that's not before this court, and that's not really before us at this point. We have a trial coming up in
I
2025.
understand. It just seems like the more we talk about this, there just seems to be a lot of interconnection between the forcible detainer and the quiet title. And I understand that there's cases that said, I understand the Supreme Court has said, just because there's a quiet title action pending, that does not mean that a forfeiture, that a forcible detainer cannot proceed. I understand that.
Right.
But the competing case law also says you have to meet the prerequisites of a forcible detainer. That's your client's burden.
Right. And Your Honor, again, what they're asking you to do is make the decision that Judge Driggs has been asked by them to make at trial at 2025. The starting point of this eviction action was a certificate of the notice of completion of forfeiture. Again, I don't know how. What they asked was that you take judicial notice of these recorded notices of intent to forfeit. I think that the prudent thing to do would be taking judicial notice of that without trying to make a decision that would rob Judge Driggs of his opportunity to rule upon all the issues and all the facts of this case, and have him make a determination of law based upon the parties' contract, the testimony of the parties' expert witnesses, and so on as to what the parties intended. The problem with this particular case is that you had two non-attorneys, two non-realtors create a contract that did not result in the creation of the documents that were contemplated by the contract. It said that there would be a promissory note and a deed of trust signed by Justin Olson. Those documents were never prepared. He never signed them, but now they're asserting that my client didn't have the right to do what he did because he should have brought a trustee's sale. That's what they're asserting in the quiet title action. So pick a legal theory, but it's improper for them to have you at this juncture make a decision that would deprive the trial court of its opportunity.
And if I made any comments that suggested that would not be the case. In fact, the colonial line of cases, all they say is if a judge is necessarily being asked to weigh in on a genuine dispute, he's not to resolve the dispute. He's to kick it out and say, I'm not dealing with this. It's not a proper forcible detainer. That's all the only point I was trying to make there. So
I appreciate that. Thank you so much for making that perfectly clear. Do you have any other questions for me at this time? Okay, thank you so much, Your Honors.
Thank you, Your Honors. Do you have any questions for me before I start?
no.
In the judgment,
If you could pull that microphone back down just a little bit.
in the judgment in the eviction action, the court did find that the defendant's claim to the property was forfeited through a contract for the conveyance of real property. According to Title 33, Chapter 6, Article 3, those are the forfeiture statutes. The court then also said prior notice to vacate was served upon the defendants. So I do think the court did make an initial determination as to what the nature of this contract was by using the appellee's language, a contract for the conveyance of real property. However, again, under the definition of contract in the forfeiture statutes, contract for conveyance, it honestly doesn't really matter the many different labels that they give for contracts that are subject to forfeiture. The bottom line is you don't get the title until the very end. A purchase contract, such as in this case, title is transferred at what should have been close of escrow. We're not arguing that Mr. Voliner should have conducted a trustee sale at this time because, again, the deed of trust wasn't executed. But it was Mr. Voliner's real estate agent or broker that prepared the contract that was signed by the parties. It wasn't prepared by the individuals. So there was a real estate professional that was guiding the process. And Mr. Olson signed what was put in front of him and believed that he would have title, to the property. I believe there is a large body of case law that eviction actions don't belong in the vendor-vendee arena. I did not include that in my brief, and I would be willing to provide a supplemental brief if the court cares to consider that issue. But payment default under the agreement that was signed by the parties does not somehow transform this agreement into something other than a purchase contract. The payment default doesn't give the appellee, Mr. Voliner, the right to unilaterally reform the contract into something that he likes so that he can cherry pick a remedy that's significantly faster than what he should have done, which is bring a quiet title action and have the Superior Court decide the nature of the agreement and the rights and remedies of the parties. And also I would like to say the quiet title complaint was not filed in response to the FED action. The FED action was filed on October 23rd, but it wasn't served until November 15th. The quiet title action was filed on October 24th, the day after the eviction action was filed, but without knowledge of the eviction action. It was filed in response to the notices of election of forfeit and the untimely affidavit of completion of forfeiture. So that portion of the testimony is correct. And finally, I don't think we're asking you to make determinations that should be left to Judge Driggs in the civil action. Again, this is an improper eviction case. We're talking about possession, and was the method or remedy that was elected by the appellee, Mr. Voliner, to proceed with his claim for possession available to him under the law. And if the court finds it was available to him, did he proceed appropriately through the notice and completion stages of the forfeiture statutes? Thank you very much.
Also, thank you for your arguments this morning. This matter is under advisement, and we will issue our decision in due course. The court will stand in recess now to set up for the next argument. Thank you.